The United Kingdom left the EU on January 31st, 2020. The transition period, during which the UK remains part of the customs union and the internal market, ends at the end of 2020. The option to extend the transition period has not been used. What does that mean for the owners of trademarks, patents and designs in Europe? The imminent end of the transition period means a turning point in the reality of life under union law. Companies that also operate in the UK must act if they want to continue to fully secure and enforce their IP rights. An EU trademark registered on December 31st, 2020 automatically receives a UK clone. That means an identical UK trademark including the priority date of the EU trademark. However, this does not apply to EU trademarks that are still in the application stage on December 31st. In this case, applicants are given a period of 9 months during which they can actively apply for a new UK trademark and claim the priority of the UK trademark filing date. The same rules apply to IR trademarks, internationally registered under the Madrid Trademark Agreement and the Protocol to the Madrid Trademark Agreement, which the EU has designated as a protected area. From January 1st, 2021, national UK rights can no longer be invoked in opposition proceedings against EU trademark applications before the EU IPO. Any pending EU litigation based solely on UK rights will be rejected. The reverse does not apply. Proceedings before the UK IPO against national UK trademarks based on an EU trademark will also continue after January 1st, 2021, based on the law that applies during the transition period. The decision is then limited to the United Kingdom, where the UK clone will automatically be available next year. Problems can arise in the future where the legal use of an EU trademark or its awareness can only be proven under consideration of its use in the UK. Corresponding data can no longer be taken into account from January 1st, 2021. Unregistered community designs existing on January 1st, 2021 will automatically continue to exist in the UK for the remaining term of protections as UK continuing unregistered design. In addition, there will be a new supplementary unregistered design, the protection of which, in contrast to the continuing unregistered design, does not extend to the EU. It only arises through first revelation in the UK. This means that even designs that are not disclosed until after December 31st can be protected in the UK as supplementary unregistered design rights. The European Patent Convention, the EPC, is not union law and is therefore not affected by Brexit. As a result, European patents with UK names will continue to be granted by the European Patent Office and will be effective in the UK. Existing UK supplementary protection certificates will remain in place. The EU regulations on the supplementary protection certificate for pharmaceuticals and pesticides are also to apply to applications pending in the UK on December 31st, 2020 for the issue of a supplementary protection certificate. After the transitional period has expired, EU trademark courts no longer have any decision-making power with regard to the UK territory or even the UK clone of an EU trademark. The privilege of forum shopping under Article 125 of EU TMR then only applies outside the UK, where it is no longer possible to take legal actions against an EU trademark infringement. Incidentally, it remains the case that Article 125 EU TMR is to be interpreted in accordance with the ECJ decision AMS NIEV of September 5th, 2019, to the effect that the proprietor of an EU trademark can bring an infringement action before an EU trademark court in the member state in which the market participants are located, to whom the infringing advertising or the like is directed, although the advertising in question was initiated in another member state. The BGH, the German Supreme Court, previously saw it differently. For example, in a judgment in 2017 on perfume brands, and did not focus on the place where the advertisement is accessible for the question of international jurisdiction, but on the place where the publication of the offer was initiated. That restricted the possibilities of legal action in Germany considerably. However, the ECJ has now corrected this point of view and, not least, has strengthened Germany as an attractive place of jurisdiction for lawsuits relating to the infringement of union trademarks. Brexit also has an impact on license, coexistence and cease and desist agreements and other contracts with a continuing debt character. For example, the question arises of how the term European Union should be understood in such treaties when it comes to their territorial scope. Depending on what the parties originally wanted to agree on, the purpose of the contract, how the parties cooperate, and what law the contract is subject to, the UK may still be covered by the contract, with consequences that one party may have a right on contract adjustment, or not, with the result that a separate new contract may have to be concluded if this should be the case in the future. The imminent end of the transition period means a turning point in the reality of life under union law. Companies that also operate in the UK must act if they want to continue to fully secure and enforce their IP rights. It is very important to review all currently pending proceedings in which UK and Union trademarks play a role for any need for action. With a view to upcoming UK clones, it must be checked whether this might not result in redundant double protection if and because the EU trademark owner already owned an identical UK trademark before Brexit. There is potential for savings here. However, caution is advised. If a double right is to be given up, it must be carefully checked whether this conflicts with non-existing license agreements, ongoing proceedings, or other agreements with third parties. If you want to register a new trademark and also need protection in the UK, you have to register a national UK trademark in addition to an EU trademark. When searching for better rights in the UK, an examination of all Union trademarks registered before January 1st, 2021 should be considered for the time being, as it will take some time for the UK IPO register to be up to date, including the UK clones. Existing license contracts should be updated. This applies, for example, to clarifying the territorial scope. Alternatively, licenses for union rights can be extended to include UK national rights resulting from automatic cloning. And if you now want to know more about European politics, YouTube has chosen another of my videos right here for you in the end screen, right next to your chance to subscribe to my channel, which I hope you already did. I'll see you in my next video. Click and enjoy. Viel Spaß!